Good afternoon. This is Sean Golding with Golding & Golding, here to discuss the basics of what do you do when you learn you have unreported foreign accounts, common reactions, and responses. So it's tax season, right? We're right in the thick of it. And unfortunately for a lot of taxpayers, they learn for the very first time that they have foreign accounts, assets, investments, and income that should have been reported in prior years. Either they didn't know they were supposed to tell their accountant didn't know what they were supposed to do, or they misunderstood TurboTax, or they just didn't want to report. Let's go through some of the basics and what you can do about it and what some common reactions are. Foreign accounts compliance, you might have heard terms like FBAR and FATCA, Form 5471, 3520. The idea is if you're a U.S. person, such as a U.S. citizen, lawful permanent resident, foreign national who meets the substantial presence test, for example, you're here on an L1, H1B, E2 or 3O visa. You don't have to be on a visa, but it's common. Even a tourist visa like a B1, B2 or an investment visa, EB5, and you meet the substantial presence test, any one of those categories, you're required to report your worldwide income and disclose your foreign assets. Most people don't realize this, and there's lots of different forms you may have to file. The FBAR is common. It's for bank accounts. FATCA is Form 8938. It's for assets and accounts. Depending on what type of assets and investments you have, you may have to do Form 8621, which is PFIC. You may have to do 5471, foreign corporations, 3520, gifts and trusts. So you just learned that you have these unreported foreign accounts, right? Common reactions. I'm just going to bury my head in the sand and not think about it. I'm just going to do a quiet disclosure and hope no one finds me, or I'm just going to get into compliance and resolve it, regain my peace of mind. Let's go through these, right? Offshore disclosure is the formal process of getting into compliance. If you're non-willful, you do things like streamlined delinquency procedures, reasonable cause. If you're willful, you do voluntary disclosure. By getting into compliance, at some point you'll be done and you can move on with your life. It's uncomfortable at first for lots of people, but once you're in compliance, then going forward is normally not as bad. They even have the voluntary disclosure program, which is for people who are willful. So the IRS understands that you may be non-willful, you may be willful. Even if you're willful, you can use this to get into compliance, and it's important not to confuse willful with criminal. Many people can be willful. Well, most people are non-willful. There are plenty of people who are willful and not criminal. To be willful and criminal is a very small, minute category of people, right? Other option is just bury your head in the sand, hope it goes away. I mean, there's plenty of people who have turned left when it came time to getting into compliance with the IRS, never to hear from the IRS ever, right? The IRS is limited capacity, right? Not everyone gets audited. The IRS doesn't find everyone who's out of compliance. The problem is if they do, if you're one of the unlucky ones, then the penalties can be significantly higher. Another option some people choose, which is a bad option, I will come out and say it, is quiet disclosure. With quiet disclosure, you're proactively getting into compliance by either filing forward or going back and filing for prior years without going through one of the amnesty programs. Why is quiet disclosure a bad idea? It's this simple. When you do a quiet disclosure, you are basically an intentional quiet disclosure. Let's start with that. Some people didn't know there was anything they had to do, and once they learned, they fix it. But if it's a quiet disclosure and it's intentional, and the IRS finds you, well, now you're kind of staring down the barrel of a fraud or possible evasion claim. Because if the IRS could show that you intentionally misrepresented or you intentionally omitted, then that becomes a bigger problem. That might leak into an IRS special agent investigation, and that could become criminal, okay? In general, violations are civil. They're non-willful. You have pension accounts you didn't know you had to report. You're on some family business you didn't know that you have to use attribution. You have foreign accounts that you had because you worked there or because you lived there or you had them before you came to the U.S. Try to avoid the fear-mongering. It's horrible. It's brutal. It's mainly by attorneys who don't know what they're doing. If you don't do anything, you may get a soft letter. You may be put under audit or examination, or you may already get penalties. Now, if that happens, you may lose the opportunity to voluntarily get into compliance. Not really with a soft letter. A soft letter is more like a warning. And if you get that letter, you could typically still do something like streamline. But if you've already been placed under audit or examination, or you've already received a penalty notice, you can't do that. Instead, you have to work backwards and try to abate it by showing reasonable cause and not willful neglect. This is all we do at my firm here. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate to your matter and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.